Welcome back. We are discussing Howell and Hamilton. And so I wanted to break this down. I wanted to show the application for Florida and their analysis for the case that we talked about, in addition to the California version, right? And as you can see the difference. So let's take a quick look. So Johnson, right, in the Florida case, Johnson, the plaintiff, sought to recover her full medical expenses despite Medicare's reduced payment. And the trial court allowed Johnson to introduce the full billed amount, but the defendant appealed that decision, right? The appellate court ruled that the compensatory damages should be limited to the Medicare's payment as it satisfied the healthcare's provider's charges, right? And so in this case, it involved past due medicals that was covered by Medicare. Therefore, the damages, they were saying, should be the actual Medicare payment, not the total amount billed, right? This is what Florida said. Now we're looking at California. California is saying, okay, this is a healthcare provider. The bill was $189,000, right, for her medical treatment. And the health insurer negotiated and paid a reduced amount. Okay, so, and which is $59,000, which is the full satisfaction to pay those bills. Now, she was, again, 189 was the medical damages, right? Was what that bill was for. So the Supreme Court in this situation was in favor of Hamilton meets. They stated that the plaintiff cannot recover more than what they actually paid. But they took it a step further and they said, or incurred for medical expenses, because they were anticipating further litigation down the line. And they wanted to nip it in the butt now. They said, okay, they want to grant, it says it would grant them a windfall rather than to compensate them for the actual economic loss. Because their goal is to compensate for economic loss. It's not to give them above and beyond money, in their pocket, which is what the attorney's objective is, right? But that's not what the goal of, you going to court and getting paid for that. I mean, above and beyond would be pain and suffering, and that's something different, right? So in this situation, this is what they're saying. The Florida court talked about past due balance. They never talked about the incurred. It wasn't specifically stipulated.